important for Jessup, but also important for how states interact with one another. So in my time at the UN, I definitely notice the use of state responsibility, potentially not in the same kind of format that you may be used to, with respect to, I guess, the formula that you're given when you are taught state responsibility, but it's definitely something that affects how states relate to one another. So the first slide we have up, I hope you can see, is a photo of Sandinista rebels, which are riding a tank in the main square of Nicaragua in 1979. Everyone will know that Nicaragua case is super important to state responsibility for so many reasons, but in particular because it gives us the overarching scope about what could be attributed to a state, in this case, the United States, when they're using people and groups that are maybe not necessarily US uniformed personnel, but are doing the work of, for in this case, the United States. So starting off with what is state responsibility. So obviously states are just broader bodies. They're kind of constructions based on borders. They don't act by themselves. Individuals associated with the state act. So in my case, as an Australian official, whatever I do in my job, whether that's at the United Nations or here in like the everyday work of being a government official, is technically something that the Australian government does. So what we do with state responsibility is we determine how my actions as an official might be attributed to Australia. And if I do things that are potentially out of the scope, whether Australia can disconnect itself from my actions. And the reason for that is that when something illegal in international law happens, a state is obliged to do something to repair the damage that was originally caused. So some important notes before I go forward. Compliance with domestic law is not a defense to a breach of international law. So if I say, or a state says that while we did this activity on the international stage, it was in compliance with our own domestic law, whether that law was existing before the breach that they did or afterward, like a retrospective law, which sort of justifies the activity after the fact, and they say that they're in compliance, it does not matter. It is still a breach of international law, and state responsibility can come in to reinforce that. And the second important point is state responsibility is a residual body of law. So if there's a legally binding agreement between two countries that might change how they relate on a certain breach or with their responsibilities with one another. So it could be a bilateral agreement about the treatment of individuals between the two countries. Could be an agreement about how they would resolve disputes, how they would find disputes. If that does affect the responsibility of the state, then technically state responsibility can't usurp that particular law. Okay, so that's just some background on state responsibility. Now, one of the most interesting parts about state responsibility is it's a difference between secondary rules of international law and primary rules. Can anyone tell me what the difference between a secondary rule is and a primary rule? I actually can't see people, so I'm just gonna see that. So if anyone can tell me the difference between a primary rule and a secondary rule, let me just like signal your person in the Zoom, like put your hand up or unmute yourself and you can explain it, and then we'll keep going.
Yeah, I think now you're already displaying it on your slides, but primary rules concern the actual violations of international law. and the
Yeah.
intentionally wrongful act, and the secondary rules are then concerned with the consequences that arise out of this primary breach.
That's right. Oh my gosh, I can't believe you can see the answer. So that's a trick for young players. But yes, that's Julian is right. So what happens with this is it's sort of like domestic situation where you have you might have your criminal law code that affects, you know, who is doing criminal activity, but you could never actually convict that person of that activity until you go through some significant bodies of law with respect to the evidence of the criminal action and things like that. So, and how you introduce that evidence in court. So it's the same kind of distinction in international law. We have the primary rule, which is, say, for example, the violation of a treaty. You have the facts that you would point to that indicate that that has happened, that primary rule breach. And the secondary rules of are state responsibility, where we talk about how the breach could be attributed to the state, what the state would have to do to make reparations for the breach. And then that third one, which is what circumstances you can use to avoid being considered responsible for a state. Responsible for a breach as a state. So it's an interesting dynamic because you have to jump in and out of the primary rules and the secondary rules in order to prove a broader state responsibility issue. So I have a structure here which may or may not work for everyone, but it's how I think about it, and it may be helpful for you too. So firstly, we have an internationally wrongful act, which is derived from that primary rule breach, and also the facts that we point to indicate that the primary rule has been breached. Then you can see a red line that goes through them, and that is has to do with the connection between all of them. So we go down this line to get all of these things done, and that is how we connect attribution, the breach, the whole thing up and down this line here. But state responsibility is only concerned with two activities. One is attribution, and the second are the legal consequences. And you can see the legal consequences here are the requirement to pay reparations or do reparation. And secondly, legal consequences, if you can get out of it, obviously you don't have that same kind of obligation. So that's just a structure to try and help situate how we talk about the secondary rules and the primary rules. So where can you find the rules of state responsibility if they are secondary rules? So the best way to locate the articles of state responsibility, I just said it right. The best way to locate state responsibility rules are in the articles on the responsibility of states for internationally wrongful acts. And this is the one that's annexed to the resolution in 2001. The funny thing about the articles of state responsibility is you need to know a little bit about the International Law Commission to understand why we have these articles. Because the International Law Commission is a body from the United Nations, a body of some of the best international law minds who are tasked by the Sixth Committee of the UN to write draft articles with the intention that over time, I mean, some of these take 20 or 30 years, eventually the International Law Commission will release draft articles. And these articles they're considered draft because then once they're finished, all of the member states would come together and create a international convention based on the articles. So you have articles in conventions, you have articles here in draft ready to go straight in and finish up. The thing is about the articles on state responsibility is that the reason they're not a convention or a treaty is because none of the states could agree on which articles they truly believed reflected international law or they wanted to be bound by. And this is just a little bit of history that's important, because in Jessup, you're going to get a lot of questions about whether or not that article, as annexed to the resolution, is reflective of international law. Because if states couldn't get around together in a room to decide that they wanted to create a treaty or a convention on this, then they're not going to, then there is obviously enough discontent within the member states that that may or may not be an article which they consider international law. Now, enough time has passed since the draft articles were created, and there's been many iterations of them. That's another thing to be wary of, is there's 2 draft final products, and then the one that's annexed to 2001 resolution. And the one that's annexed to the 2001 resolution is the most reliable one, and it has some great commentaries which you can go to discuss where this article comes from and what it looks like. So that's one thing to just be wary of, is a lot of this is contestable, but a lot of it, because it's been around for a long time, is actually considered customary international law. So in the absence of a convention on state responsibility, which you can see I've crossed out Article 38(1)(a) of the ICJ statute, because that's not a source for this body of law, we look to the articles on state responsibility to be either custom, a general principle of law, or, because the ILC is full of such very illustrious members of the international law community, potentially it could be considered a judicial decision, or one of the highly qualified publicists, if it's been referenced in different cases. So, for example, Article 1, we can easily prove is customary international law, and to some extent a general principle of law. And the reason for that is because Article 1 of the draft articles states that an internationally wrongful act entails the responsibility of states. So what that means, I mean, firstly, there are many ways I would consider approaching this. Is firstly, it is such a basic premise of this entire body of law that it would be considered an agreed article, because what is the point of the rest of the law of state responsibility if we don't think that a breach of international law results in any kind of responsibility of states? But then secondly, that article itself has been affirmed multiple times in, for example, the Rainbow Warrior case. And then in addition, it's in that in the draft articles of state responsibility from 2001. So it's a highly qualified publicists. And in addition, it has in many judicial decisions and other activity which is listed in the commentaries to give ground to the fact that this is a customary international law rule in and of itself. So it's a bit of a complicated situation, but it's just a heads up, because in Jessup, you're going to get so many questions that potentially, if you start getting into the really detailed parts of state responsibility, you might get a lot of questions about whether or not that particular circumstance precluding wrongfulness or a different element is actually considered evidence of customary international law. Okay, so I'm just going to jump out of this and see if there's any questions, because I can't see you guys while I also do the slides. So that's a downer. So if you have any questions, please ask now. If not, we'll jump on to the next part of the discussion. I don't see anyone. Cool. Okay. Great. All right. So we will proceed to this really another important case, aside from the Nicaragua judgment, is this case here, which is US diplomatic and consular staff in Tehran. Really interested to know if anyone can tell me a little bit more about this case. So I'll just do a little intro on why it's important. And then if someone could, I'm going to ask 2 questions, so get thinking. So to entail the responsibility of a state for an internationally wrongful act, you need to prove, obviously, the existence of an internationally wrongful act. And in Article 2 of the draft articles, there are 2 requirements. Firstly, an internationally wrongful act exists if there is an act or omission that is attributable to a state, and that act or omission constitutes a breach of international law. So you can see how we are firstly talking about attribution, and then secondly talking about that primary rule obligation. So you need both elements. That was covered by the Tehran case. I have sort of, two questions. Firstly, can someone answer what the primary rule breach was in the Tehran hostages case? And then secondly, what the attribution issue was. So those two aspects. Any volunteers? Julian, over to you.
Yeah, I think the primary obligation was to protect consular missions from other countries in your own country, in this case, the US Embassy in Tehran. And the issue of attribution was that it was those were students that were not directly affiliated with the state, and the ICJ then had to somehow argue between the students and the regime.
Perfect. Great answer. And does anyone have any ideas why in the draft articles they tend to prove attribution first? This is a broader question, because in many different kind of legal problems, you kind of talk more about the breach. Is there a reason, do you think, why we tend to in international law talk about attribution first? Any takers on that question? Yeah, Jose.
Hi. It's because there might be a breach, but if you cannot attribute that breach, there is not a responsibility.
Perfect. Great answer. And a part of it, one of my international law lecturers once explained to me, is that if you walked around accusing countries of a breach without attribution, you create such bad relationships. And I always think about that because it is such an interesting part of international law, is that at the end of the day, you need to be really, really correct about what you're saying, and you can't have any holes in the story later on. Because if you start claiming that someone has breached something and then it all falls apart later, you've already done so much damage in the first instance. So yeah, great answer. So that is sort of the internationally wrongful act part, which is very, very easy. I will move now to this method of simplified problem solving, which I have kind of created as a way of demonstrating the simplest way to do state responsibility. So I think we've already covered off on my points about different secondary primary rules. So you'll see blue, we mean state responsibility, we mean a secondary rule. Green, we mean that primary rule. Blue again, we mean state responsibility. And then also down here, we're talking about a secondary rule, we're talking about state responsibility. And this is, we'll come to this and you'll probably know why I have the pair of scissors. So attribution is really interesting dynamic. I'm going to try and do the presenter view thing. Gosh, I'm very non-tech. But here is an example of attribution I think is the easy form. So I've split them into sort of 6 different ways of doing attribution. The first is sort of the really simple attributive situations. So firstly, when you're a state organ, that's, for example, myself exercising official authority at the United Nations as a lawyer for the Australian government. It's really simple who I am, what I'm doing. I wouldn't do it if I wasn't working for the government. And so we're talking here about military, police, officers of the court, public servants, things like that. Very simple. And also, in addition, we're talking a little bit in this one, the real complex part is more to do with different positions that don't actually have, I guess, a bestowed governmental authority. There's there are a few cases where we're talking about like religious leaders, and if those religions are really important to the state. So like I think about sort of Australia's relationship with countries in Southeast Asia, and some of those countries have monks and others as key parts of their government, even if they're just running religious services. So you can still be a state organ if you through the methods of your government or tradition, you have sort of a level of that kind of power and authority. And then Article 5 is a really simple one as well, where it's conduct of persons or entities exercising elements of government authority. And this is when the states kind of give those powers to bodies which are not normally state organs. So I have this photo up here of the Vietnam Airlines because they were tasked by the Vietnamese government to do all quarantining and sort of biosecurity measures in 2020 in response to COVID. And that was all done by their persons, like their staff, on Vietnam Airways planes, when it would have normally been done by biosecurity workers on the ground in the airports. And the state gave them a bit of money to help like recoup their costs. And so that was something of like a government function being just given away. So you see this often with private security companies, airlines, shipping companies, that kind of thing. It's very clear though when an activity is normally done by a government. Then I think it's getting harder to do attribution is these two activities. These are state organs that are at the disposal of another state. So you're picked up and given to another state with their consent to assist after an emergency or in a pandemic or that kind of thing. And the responsibility shifts from that original giving state. So you can be in, a Guatemalan military uniform, but if you're doing work in another country for the purposes of the country you've been given to, and you're like enmeshed in their system to assist with some sort of emergency, then any violation of international law comes back to the country you're assisting, not Guatemala, even though you're wearing the uniform. That's the kind of situation. It actually hasn't come up as much as international lawyers thought that this mechanism would actually come up. So in the draft articles commentary, you see a lot of references to the idea that this might happen a lot, but in reality, it hasn't happened so much. And then Article 7 is the more common attribution issue. So this is acts of state organs and persons exceeding the authority that they have been given. And this can still be attributable to the state because if things are a little bit blurry, the state still has to take responsibility for the people under their control. So while states are not generally liable for the acts of private people, you have to make a distinction. So if I collect, if I'm an Australian government employee and I go to the Solomon Islands and I rob an old lady and steal her handbag and she's gravely injured, there's really no reason for me to have ever done that. It's totally outside of the bound of my particular responsibility. And so that can be disconnected from Australia. However, if I am like this private military company, which is funded by the Russian government and given instructions to go and act in different countries, and I am still doing things that are manifestly unlawful, I'm killing people and doing things that are not allowed, but the instructions are fairly broad, and technically I'm still official, and technically I'm still using a weapon provided by Russian authorities, then it's possible that I could be considered an organ of the state, and that state can be held responsible. So this one is really, really complex, and it definitely is a blurred line, and it connects somewhat with the next, I think, hard attribution issue, and that is conduct directed or controlled by a state. And this is where the Nicaragua case comes in very strongly. So we're talking about actors that can be pretty much entirely private. They're guerrilla movements, things like that, but they are funded and directed by another country, and direction and control by the state has to be integral part of their operation. So what they do is given specific instructions from the state, and also just a general dependence and support, financial support of the state is insufficient. And that was something that the Nicaragua case taught us. So does anyone have any questions here at this point? Great. That means you've been taught your state responsibility at university, like, really well. Cool. Oh, Brian? Yeah.
Thank you. I want to ask you, how has this case contributed to our international legal systems?
The Nicaragua case in particular?
Yes, in matters of jurisprudence. How has this been reflected in the international jurisprudential system and international jurisdictions?
So I can't speak particularly well about how the Nicaragua case in the ICJ has been put into domestic law, because my Australian upbringing is such that, like, there's a very odd relationship between international law and our domestic law. But I know, like, in many instances, some courts, including like regional courts, etc., have referred to this jurisprudence. I would say that the most critical part about this case is that at the end of the day, the evidentiary burden to prove just how involved a state has to be considered responsible for the actions of a terrorist organization or a guerrilla group is now it is quite high. I think, like, from an average person's point of view, if you were pumping significant amount of money towards a guerrilla group, and in addition you were giving them like general support, that, like, in most lay people's case, that would be considered enough, of a parental like role to be considered to be attributable, right? But in this instance, the ICJ actually said, no, you need to be specifically directing and controlling. And that means that if you want to prove attribution, you need to be providing evidence that, like, there was some deeper interest in what the guerrillas or the terrorists were doing. And so you see that now with all sorts of terrorist insurgent groups. The Middle East is one of those examples, but it's probably not relevant right now. But countries where there are lots of proxy wars where they absolve their responsibility because they're light on the details of what those terrorist insurgencies do. Maybe in the past they would have been a bit more clear, but now they know that clarity equals responsibility. So we have more ambiguity in that space. That's why I would say, like, the big problem or the big outcome for Nicaragua is that level of detail is so much more comprehensive than I think we would have thought, but it suits states very well. I hope that answers your question. Cool. All right. So that is I think the hardest one to prove. You need to be talking about instructions, direction and control, those sorts of things. So I think that pretty much covers that. Oh yes, one more point. Article 11 is the draft articles, catches conduct which is not attributable under those prior ones if the state consents or acknowledges and adopts the conduct in question as its own. So some guerrilla groups go and do some stuff. It's pretty unclear who is involved or who's funding them. If the country steps forward and says, we directed them to do these 3 operations, and say the guerrilla group did 2 extra, then technically the state responsibility extends to the 3 operations which the state consented and said that they did. So really important point about what you would say, I guess, like the importance of how states speak about activities. You won't see them take responsibility for things very quickly, very slowly indeed. Okay, so at this point, we're kind of here at this this juncture. So we have done attribution through those 3 mechanisms. Then we have to talk about that violation, that internationally wrongful act, using the primary rules. Then we start talking about reparations, because reparations are innately tied to what the violation was, and we'll see why that is in a second. So reparation is if you commit an internationally wrongful act, you have to make reparations. There has to be legal consequences. That is what state responsibility is all about. So Article 30 and 31 of the draft articles, in addition to the Chorsau factory case, which is very useful in explaining reparations in particular, say that there is an obligation to cease any continuing act which is in violation and offer appropriate reassurances of non-repetition. So often this is not actually that common, because it takes a long time for international law to act. So sometimes, like the act that was in violation was a one-off thing, and it's actually already finished, and then the court is hearing about it. But there are often times where if you can prove state responsibility and an internationally wrongful act, there is an automatic obligation to cease that continuing act, that continuing violation, whether or not it's environmental damage, maybe it's economic sanctions, maybe it's violations of humanitarian law. You have to cease the moment that this kind of state responsibility issue has crystallized. Then there is an obligation, a second one, to make full reparations for the injury caused by the international wrongful act, including damage, paying damages, whether they be material or moral. And the idea behind reparation is they pretty much act like what has happened never happened. We just reestablish the situation as though nothing happened, and we can carry on in our relations together. And obviously, sometimes that's not entirely possible. So they provide us with 3 options. Well, yeah, 3 very widely encompassing options for reparation in the draft articles. And that's they can be used in combination with each other, but technically there is a primacy of restitution. So restitution is the first port of call, and that's to reestablish the situation. So I have a photo here of the military guard at the Temple of Preah Vihear in Cambodia, because this is a really interesting case about reparation, because in this case, Cambodia really wanted a lot of artifacts back. So the Thai military forces had come into the temple and stolen many artifacts over the years. Some of those artifacts had gone on to be sold to museums and private collectors, and others were being held by the Thai government. And the part of the restitution was the idea that the Thais had to provide back to Cambodia as many of the artifacts from the temple as they still had. So that is an example of restitution. Obviously, sometimes that's just not possible. The artifacts are really old, they've been broken, they just don't exist anymore, they've been lost, or like they've been sold, as I said, to museums and collectors. So you have to give back as much as you can. Then that's why you step down to the compensation, which is to make up in compensation what you cannot do through restitution. So in an actual fact, compensation is the most common form of reparation. And that is because often these things are like destroyed. And unfortunately, the world isn't great at returning things. It's not really great at like, how do you restore back to original people's lives? You kind of can't do that. So in all reality, compensation is the most common form. And so what that is just like in domestic law, it's a financially accessible amount based on damage of property, economic damage, loss of profits, but also it can relate to loss of lives, heartbreak, hardship based from death, the price, if you can like enunciate it, of like interventions with people's home lives and families. So there's a calculus that's applied in domestic systems, which can be applied in the international system as well. And then the third one is satisfaction, which is a very weird and large kind of form. And you can see this in the ILC draft articles commentary, where ultimately at the end of the day, there are often times where restitution won't work, compensation won't work. And so an example that was given to me when I was a student was if you kill someone's king or queen, like the head of state, firstly, you can't give them back, so restitution doesn't apply. How do you financially assess? You can obviously financially assess the value of a person in the normal world who is, making money for their family and the loss of income there. But the killing of a head of state is of such grave level that there's the financial amount can't really be fully encapsulated. And the reason for that is that the killing of a head of state is such an affront to the dignity of a state. And so satisfaction is there to be the big sad apology that's at the end that says, I will never do it again. I'm so sorry. And it seems kind of funny because when you're a child, you are taught to say sorry first, but states are like insolent children and they just don't want to say sorry to each other. So honestly, the thing at the end, satisfaction is often just a big apology. And secondly, if states don't want to say sorry, technically the gaining of a remedy through the ICJ or another tribunal is a declaration of wrongdoing, could also be considered satisfaction. So if they really don't want to say sorry, you at least have your ICJ declaration that says that they were in the wrong, and that's, I guess, your satisfaction at the end of it. All right. So I just finished reparations. I'll stop if there's any questions about reparations. No. Okay, Justin, go ahead.
Hi, I have a quick question about reparations. What happens, for example, if a state just won't pay up the reparations that they have to do? What could be the consequences of that?
Yeah, this is a massive issue. So the court has been sort of requested to maybe consider like reissuing like a continuing, sorry, I said that wrong, reissuing like a verdict to say that they're in continuing breach, right? If you have a declaration that says you need to be paying and you're not paying, then you continue to be in breach of your international obligations. There are also sort of demands that, or there is a school of thought that you're now also entitled to countermeasures because if you aren't obeying your international law obligation because you're in breach of this declaration from the courts, then the state that's affected can issue countermeasures against you to try and bring you into compliance with that ruling. So sanctions, unilateral sanctions, is a really good example of how that would work. But at the end of the day, states, it's not actually that uncommon. It's not actually that common that states don't comply. And that we often think that international law is toothless and has no way of ensuring compliance. But the actual numbers of cases where non-compliance was the total outcome is pretty thin. So like Libya and countries that were in that Libya at that time, really recalcitrant, really unable to be touched. They still complied with some of the declarations against them, maybe not all. But ultimately, if they want to restore relations with the outside world, they do have to start complying with international law. And so that's why you end up with these countries that are really far away, like North Korea and things like that. But, you know, the rest really want to engage in the system and don't want to be subject to those kinds of like bilateral or multilateral measures against them. They're kind of forced into compliance for a soft mechanism. But it's a really good question. And those two ways, that continuing breach and that countermeasure thing, is probably the best practical balance, if that makes sense. And another question from Brian.
Yes, yes, Professor. Is there any other kind of reparation, like a mode of reparation, but not economic?
Well, aside from the apology, that's your, you've got the, I mean, compensation, economic reparation, the most common. States want money. Doing litigation is really expensive. If you can get a declaration that someone's in the wrong and then get your money paid back for you for your international court case, then you're doing really well. But the restitution, the return of the artifact or whatever it may be, is non-economic, really. And then satisfaction, the apology, is non-economic. Restoration of good relations is also considered to be like an outcome of the court case, which would be, you know, that's a positive thing. It has economic benefits as well. That's where I would say your non-economic reparations kind of sit. But mostly at the end of the day, the money is the key aspect, in addition to the declaration of the illegal activity. Okay, so if we have no more questions, we're here now at the cutting point. So we've done our reparations. We've kind of come all the way down the line. The scissors are here because one way you can just totally disconnect that attribution aspect at the top from your full responsibility, that chain of responsibility, is to say that there was something intervening here. There was a circumstance that makes you non-responsible. So while you may have attribution, while you might have a breach, while, you know, we might owe you reparations, this is the final thing that makes you say, but there were these circumstances that stop us from being actually responsible here. So these are some of the circumstances precluding wrongfulness. So there's 6 in total, pretty well defined. There are a few like ones that kind of hang around in academic journals, which I won't go into. So firstly, one is super easy, consent. It's under Article 20. This is very obvious. If you give freely and validity consent for a country to do something to you or your country or your nationals, and that country does do that within the limits which you have asked them to do it, you can't turn around and say that they're responsible for a breach of international law if you asked for it. Self-defense is the next article, and this is very important to note that this is taken in conformity with the UN Charter. That is Article 51 of the UN Charter, specifying self-defense. And you can't claim this circumstance if you are, for example, arguing this customary international law side of self-defense, which some states don't think exists, some states do think exists. That's a whole other lecture. But if you are acting in self-defense and that self-defense is taken in conformity with Article 51 of the UN Charter, then you are not responsible for the breach of international law which occurred. Countermeasures, which we just sort of talked about before as part of the reparations issue. These are proportionate measures taken to induce another state into compliance with an obligation if the resumption of that obligation is possible. So this is a circumstance precluding wrongfulness. So you can't turn around and say that there is a breach of international law with this state doing this activity if they're doing it as a countermeasure. They're trying to induce you as a state into compliance with an obligation which exists for you, if that obligation is actually possible for you. This has a lot of exclusions. I mean, I can't even remember all of them, so I have to go and remember down here. Countermeasures cannot be used as a circumstance precluding wrongfulness if it was against the obligation to refrain from the threat or use of force, or if it was against any obligations for the protection of human rights, or if it was more of a reprisal than a countermeasure. So those those kind of caveats in that countermeasure section don't exist. And so you're clearly just acting out. Or if it affects a use cogents obligation. So this one is really, really complex, and I think very difficult sometimes to prove, but I think it's a really interesting one. What else is there to say about this? I think those are the most useful circumstances precluding wrongfulness, in the sense that they're very easy to understand the rationale behind. But I often do find that circumstances precluding wrongfulness can be very difficult to prove in some instances. So the reason for that is that you really have to dig quite deeply into customary international law and general principles of law to prove that these things are accepted, because states will want to use circumstances precluding wrongfulness when it suits them, and then dispute the facts of what a circumstance precluding wrongfulness means when they don't want it. So, they try and have it both ways. The more complicated circumstances precluding wrongfulness, force majeure, which is an unforeseen, irresistible natural physical event or human intervention beyond the control of the state. So you have to really prove that the state had no real possibility of escaping the effects of the activity. And this includes duress or coercion, but it doesn't include, just that circumstances have changed that have made things harder to kind of do your obligations. So like if you have a very bad economic situation and that's not making it materially impossible to perform the obligation. Distress is a really great one, I find. It's really, really common in air travel, shipping, everyday life, actually. There's a lot of examples of state practice on distress. And the reason for that is because like weather and emergency events, like medical events, often happen on ships and planes. And what happens then is they have to, say they have to cross airspace, which they're not allowed to. Technically, that is a breach of that primary international law rule, and it's attributable to the state. And so there's a responsibility there. But distress comes in to say, well, actually, there was a massive storm, and, in order to save the lives of the people on board, we had to enter your airspace or your shipping route. And we tried to contact you to let you know, or afterward, we went straight back to our normal territory. And so that is, that's very common circumstance precluding wrongfulness. And then the third one, which I really like as well, is necessity, but it's really rare to be successfully invoked. So the Israeli Defense Forces tried to invoke this in the fence, in the building of a wall case. And what they said was that because Hamas and Palestinian occupation was so aggressive towards them, it was a necessity that they build the security fence. But the court found that no, there was so many other ways in which they could have stopped the hostilities between the two sides. So necessity is actually hard to prove. And one of the best ways to prove it is by the fact that often because of necessity, a lot of countries agree. So you can look to just state activities and like news articles to prove that necessity is a thing. So when I say that, what I mean by it is in the Tory Canyon case, for example, it's spoken about in the commentaries. This Libyan oil tanker was full of oil, ran aground off the coast of the UK, and the UK said, in order to avoid a massive oil spill that could have, ruined so much of the UK's shoreline, they're just going to bomb the tanker. So they just flew over the top, released a bunch of bombs. The thing went up in flames, all the oil went up in flames, and the international community didn't have any issues with that. And that's because they made a very strong case that it was necessary. So it's not often actually in the case law, but it's a really great case of the fact that, you know, that can prove state practice in opinio juris, like if you don't have any objections, then that proves that. So as you can see, we've kind of gotten down to the entirety of my simplified problem solving method, which is attribution, act or omission, which is the primary rule. You're going to have to do that one yourself with the actual treaty, but the reparations aspect, and then what circumstances can preclude the state from wrongfulness, whether that's consent, self-defense, countermeasures, force majeure, necessity or distress. So those are the 6 ways to get out of that thread of state responsibility being drawn between you and the activity. So now is a good time to stop for questions. And I know we have like 3 minutes left, but we have plenty of time for questions. And I also have a bit of a state responsibility side note, which might help your Jessup problem once we're finished with questions as well. Okay, yeah, Jose.
Hi, sorry if it's a little bit of noise, but I'm in a public place. I know that we didn't saw this in this class, but what happens if you are not the injured state and you want to invoke responsibility? You have Article 48 to draft articles on state responsibility, but somehow it does not reflect custom. It might be one of the teachings of the most highly qualified policies, but do you know case that recognize that article as custom or other source that I can rely on?
Okay, sorry, I'm gonna have to check in with you your question because it was a little bit hard to understand. So you're asking if a highly qualified publicist says that something is a source of custom, that's what you can rely on, specifically with Article 41.
8.
Article 8.
Sorry,
okay.
I don't know if I'm 48. I think it's my headphones, but
Okay.
I'm
No,
gonna
that's
speak
fine.
again. Do you understand?
You can also, do you want to throw your question in the chat?
Okay, let me go. I'm gonna say one last time if you can. Do you know any case where it has been recognized that Article 48 reflects customary international law?
Okay.
Article 48, do you know any case?
Okay. Let me just think about this. I'm just remembering my sort of capacity to recall. Article 48 and a case. Look, I don't really recall. I'm like off the top of my head. I've lost you. There you go. I don't really recall. Can you give me a little bit more, like what it, can you, I'm just really trying to remember what Article 48 is.
Sorry for not being very specific. It's
okay.
about invocation. It's about invocation of responsibility by the not injured state. It's pretty new. It's
yeah. Okay. No, this one is very new. And I mean, well, it's actually like, it's not new, right? They're all together at the same time, but the amount of jurisprudence on this is pretty thin. You're starting to get into the erga omnes partes sort of erga omnes world. The Barcelona traction case is sort of the best example. Everything else is sort of state practice. I'm not really great at sort of this particular aspect of the state responsibility stuff, but you know, like the newest jurisprudence really coming out is the Gambia Myanmar cases, where you have just such a massive gap between the country that's actually, you know, doing the breach and the country bringing the case. So there's a lot in the interim measures request on that, and the jurisdiction and admissibility of a case where the injured state is really having to try and build a case to make itself injured. But there is such a specialty about the primary rule in that case, which is the Genocide Convention. So that's where you come back to that issue with respect to you know, what like in Barcelona Traction, the 3 or 4 examples that they have where, you know, it injures everyone, the erga omnes partes basis. So like the ILC commentaries are pretty clear about what makes an injury for for a third party state, but I'm not really I can't think of many cases that really back that up as more than or as a customary international law rule. And if you think about it, you can imagine why. Cases like states aren't going to want other states to be able to bring a claim against them for something that they don't think they have anything to do with. So yeah, really, it is quite thin on the ground. But the closest I think at the moment to watch is the Gambia v Myanmar, and see if you can relate it back to that that article. But it does have a very special nature with the Genocide Convention and the erga omnes thing. So yeah, sorry. I don't know that doesn't answer your question perfectly, but
No, thank you very much for your answer. I know it's like really specific, and I just wanted some ideas. And sorry if you didn't listen to me very clearly, but I'm in a Starbucks taking this class. It was amazing, by the way, and thank you
no
again.
worries. That's okay. Any other questions? No? Yes? Calling one twice. Okay. No more questions? All right. I have my final kind of slide, which I'll share. I was like, if we have time, but I think it's kind of useful. So this is like an area of international law, which when I was first taught, was like, I don't get it. Why is this area of international law taught in state responsibility, and what does that have to do with anything? So like I had to refresh myself to do this class on this particular topic. So the thing about state responsibility and where it comes from is a lot to do with how states treated their nationals, and states treated other countries' nationals. And so I'm really passionate about kind of raising this particular point now, because the Jessup problem for this year is very specific about the treatment of nationals under the care of another state. So international minimum standards is before all of the international human rights, before all of that kind of stuff, there was a need for a state to prove that they had been wronged by the way another state treated their nationals. So you have this great quote here from the Mavrommatis Palestine concessions case in 1924. The bond of nationality which engages the interest of the state whose nationality the mistreated private person is enough for the state to be regarded as having been the victim of an internationally wrongful act. So what that's saying is, if me as an Australian, I go to Guatemala and I am arrested or something, and I'm treated very badly, it is Australia who has suffered an injury, and they can put a case in the International Court of Justice against another state for a treatment of a person. Often you don't have that, right? Like, people aren't able to be taken. You don't litigate about the treatment of individual people unless there's something very substantial going on in the International Court of Justice. So this is before international human rights law. And so what we end up having is a body of customary international law that still exists, called the International Minimum Standards, or Minimum Standard of Treatment. And what this is state responsibility for mistreatment of their nationals outside of human rights law. And you see a lot of these cases about attribution, about internationally wrongful acts against different nationals coming from bilateral commissions. So the US-Mexico Claims Commission. You also had the Iran-US Claims Tribunal. Then many old cases like Greece and Morocco in the PCIJ, because states often prosecuted each other because their investors or ministers or whatever were harmed in going from state to state. So you can now see this old tradition reflected slightly in the Articles of State Responsibility at Article 44, but that doesn't stop this entire body of law from still existing. So it's one of those things where a state can now claim state responsibility because an individual that went into another country was treated so poorly. In the US and Mexico tribunals, they claim a very high bar. Some of the cases say a total outrage, bad faith, willful neglect, insufficiency of governmental action. So it's very, very substantial. But they also 2 years later said that ultimately an alien who is treated not in accordance with ordinary standards of civilization would be considered a breach of international minimum standards. And it doesn't matter what the local conditions are. So they have to be treated with a certain level of respect. Otherwise, you are breaching the responsibility that you have to treating another state with a certain standard of respect. And so this is a really interesting history and side piece to interstate responsibility, which is worth having a look at and to see if it would suit this Jessup case. I make no disclaimers if it's a good choice or not, but it is a very strong part of the history of state responsibility and does still exist out there. And it is one way that states can litigate against each other about the treatment of nationals and invoke state responsibility for breaches of the treatment of their own citizens. So that's a really interesting body of work worth exploring. And yeah, I will leave it there unless there's any further questions about that or anything else. And if anything I said didn't really make much sense and you want me to go over it, I can totally do that. Santiago?
Hi, Ms. King. Well, I have a question in relating to this topic. Don't you think that the Vienna Convention on Consular Relation is a treaty that could set a minimum standard different than those established in the customary international law?
Yeah, that's a really, really great point. I definitely think it could. And obviously all of these cases about MST and IMS came out before the Vienna Convention. But I think there is enough of a kind of distinct body of law on this that is in addition to the Vienna Convention on Consular Relations. So if you kind of took the Vienna Convention and you stripped down all the different bits and pieces that talked about how the consulate is like a sacred place, not the right terms, but sacred place, how it's, inviolable, other different aspects of like how diplomatic and consular relations occur. And then you really got down to the treatment of nationals. How much does that convention alter or change what's in the body of law from IMS and MST is a question that you can ask. So I agree with you. I definitely think the Vienna Convention on Consular Relations changes the relationship, consular relationship for sure. How much does it affect the obligation to treat nationals is going to be in very specific articles. And this is just a creative legal argument which you would have to discharge to say that the Vienna Convention on Consular Relations exists. It changes potentially the relationship, but not enough to absolve this strong body of customary international law. So it like could go both ways. And then the other side of the argument would say, absolutely, the Vienna Convention on Consular Relations has changed this entirely, and there is no cause for this aspect of international law at all anymore. So I can't give you a definitive answer, but I can show you the two different directions it's possible to go in.
Yeah, I got it. Thank you for the idea, Ms. King.
No worries. Anyone else? Cool. Okay, great. I'm very happy to have managed to get through this in like a vaguely reasonable amount of time. I'm sorry if I spoke very quickly or like went through too fast, but the articles on state responsibility are a huge and important part of the law, and it's a real challenge to like smash it all into 1 hour. But I hope this has been a good refresher for you at any rate.
Thank you so much, Hayley, for the time and for this great presentation that you gave. I think this was the most interactive lesson that we have so far. So thank you. And thank you everyone for joining. I think Julian has, no, they are just clapping. So we're all clapping you. Thank you, Hayley. Thank you so much.
No worries. Good luck with your Jessup preparations.
Yes.
Bye.